In drug cases, similar to many other cases, the first thing that I look for is whether or not there is a way to constitutionally challenge the initial seizure of the drugs or of my client. In other words, did the cops violate any of my client's constitutional rights when they arrested him or her and seized the evidence that they intend later on to use against them at trial? For example, when a client drives a car and he's stopped and then the car is searched, did the officers have probable cause to stop my client, then to seize my client, and later on to search the car? So the first thing that I do is I look to see if there's any way to challenge pre-trial the seizure, arrest, and taking away of the evidence from my client if it was done legally, usually through Fourth Amendment challenges. Then I look to see what are the defenses for trial that are potentially possible in every case. And every case is completely different. So one set of facts is never the same as another set of facts. But in general terms, what I look for is to see if the state can prove beyond a reasonable doubt that my client had, number one, actual possession of those drugs. Did he intend to possess them? And did he have knowledge of the drugs? And was he there? Were the drugs hers? For example, you have a number of people driving in a car, and the police stops the car, searches the car, and find drugs. The drugs were not found on my client, but my client is charged. Is the evidence to show that my client had the knowledge that the drugs were in fact in the car? What is the knowledge that my client, who sat in the back seat, knew that the front passenger in between his legs had drugs, for example? Or if they go into a house and they find drugs in a house, and there's multiple people living in the house, how can they connect my client to the drugs? And that is what you really need to attack when you have drug cases with multiple people or with scenarios where your client did not know that the drugs were there, or that the prosecutor cannot prove that your client knew that the drugs were there. Because it is always the prosecutor's burden to prove the case beyond a reasonable doubt. It is the prosecutor that needs to show to the jury that your client had intent and knowledge and possession.